Hello and welcome students to lecture 2C on Mootology and Mooting skills. This is your professor Muhammad Aammar Zaki. So the next point is take pains to select your best arguments. Concentrate your fire. The most important, the very most important step you will take in any presentation, whether before a trial court or an appellate court, is selecting the arguments that you will advance. A mediocre advocate defending a good position will beat an excellent advocate defending a bad position 9 times out of 10. Give considerable thought to what your arguments should be and take it over with your associates. Bear in mind that in an appeal, trial counsel is not necessarily the best person to make the call. Extreme attachment to a rejected point can color one's judgment about which ruling lend themselves to effective challenge. Think of the poker player who can't bear to fold three aces even after it has become to seem very likely that the opponent has a full house. Scare shot arguments is ineffective. It gives the impression of weakness and desperation, and it insults the intelligence of the court. If you're not going to win on your stronger arguments, you are surely won't win on your weaker ones. It is the skill of the lawyer to know which is which. Pick your best independent reasons why you should prevail, preferably no more than 3, and develop them fully. You might contend, for example, that breach of contract claim is barred by the statutes of limitations. The performance complied with the contract and any deficiency in performance was accepted as adequate and hence waived. Of course, each point may be supported by several lines of argument. Lawyers notoriously multiply their points, just as they notoriously multiply their verbs. Some of the multifarious point of 10 turn out to be just earlier points stated differently. Sometimes they result from including the pet theory of every lawyer on the case. Don't let that happen. Arm wrestle, if necessary, to see whose brainchild gets cut. Don't let the client dictate your choice. You are being paid for your judgment. On the surface, it might seem that a 10-point argument has been overanalyzed. In reality, it has been underanalyzed. Counsel has not taken the trouble to determine which arguments are strongest or endured the pain of eliminating those are weakest. This is very important part. Communicate clearly and concisely. In an adversary system, it's your job to present clearly the law and the facts favoring your side of the case. It isn't the judge's job to piece the element together from a wordy and confusing brief or arguments. Quite often, judges won't take the trouble to make up your deficiency, having neither the time nor the patience. The judges considering your case have many other cases in hand. They are impatient, unforgiving audience with no desire to spend more time on your case than is necessary to get the right result. Never, never waste the court's time. Having summoned the courage to abandon feeble arguments, do not undo your accomplishment by presenting the points you address in a confused or needlessly expensive manner. They must be presented clearly and briskly and left behind as soon as their content has been conveyed, not lingered over like a fine glass of port. Iteration and embellishment are rarely part of successful legal argument. In a recent case before the Supreme Court of the United States, an appellant brief took 10 pages before mentioning the critical fact in the case, then took another 7 pages to discuss peripheral matters before setting forth the legal rules that govern the case. No judge should have to cut through 17 pages of pulp to glimpse the core of the dispute. Avoid the temptation to think that your brief is concise enough so long as it comes in under the page or word limit set forth in the court's rule. And more still, the temptation to insert additional material in order to reach the page of word limit. Acquire a reputation as a lawyer who often comes in short of the limits. It's worth reading carefully what this lawyer has written. The judges think there's, there's never any padding. The power of brevity is not to be underestimated. A recent study confirms that we all know from our experience. People tend not to start reading what they cannot readily finish. Always start with a statement of the main issue before fully stating the facts. Cicero advised that you must not spring at once into the fact specific part of your presentation, since it forms no part of the question, and men are at first desirous to learn the very point that is to come under their judgment. In the 1981, the rules of the Supreme Court of the United States were amended so that the first thing a reader sees upon opening the cover of a brief is a question presented. Many court rules, however, don't require issues or questions presented to be upfront or even to be set forth at all. That's regrettable, because the fact one reads seem random and meaningless until one knows what they pertain to. Whether you are filing a motion in a trial court, or an appellate brief, or for that matter an in-house memorandum analyzing some points of law, don't ever begin with a statement of facts. State the issue first. But while your statement of the issue should come from a full statement of the facts, it must contain enough of the facts to make it informative. Whether the appellant was in total breach of contract is a little help, but not much. Fill in the facts that narrow the issue to precisely what the court must decide. The appellant delivered a load of stones 2 days later under a contract, not providing that time was of the essence. Was the appellee entitled to reject the delivery and terminate the contract? Now let's come to appeal not just to rules but to justice and common sense. Courts have been known to award judgments that seems to be unjust or to defy common sense. A defective statute or a defective Supreme Court precedent can require such a result. Don't count on it. Consider the philosophy of Lord Denning, regarded by many as one of the greatest of 20th century British judges. My root belief is that the proper role of a judge is to do justice between the parties before him. If there is any rule of law that impairs the doing of injustice, then it is the province of the judge to do all he legitimately can to avoid that rule, or even to change it so as to do justice in the instead case before him. He need not wait for the legislature to intervene, because that can never be of any help in the instant case. To be sure, Denning was a renowned judicial activist, or a notorious one, if that is your view of things. But a similar, if not quite identical, approach was endorsed by the famous Chancellor James Kent of New York. I saw where justice lay and the moral sense decided the cause half the time, and then I sat down to search the authorities until I had exhausted my books, and I might once in a while be embarrassed by a technical rule, but I most always found principles suited to my views of the case. Now you may think that the principles contained in the authorities ought to lead a judge to his or her conclusion, rather than merely provide later support for a conclusion arrived at by application of the judge's moral sense. And you'd be entirely right. We are giving advice here, however, not to judges but to the lawyers who appear before them. You can bet your tasseled loafers that some judges, like Lord Denning, will be disposed to change the law to accord with their moral sense, and that many more will, like Chancellor Kent, base their initial decision on their moral sense, and then score the law for some authority to support that decision. It is therefore important to cause to your case. It is therefore important your case to demonstrate, if possible, not only that your client does prevail under applicable law, but also that this result is reasonable. So you must explain why it is that what might seem unjust is in fact fair and equitable in this very case, if possible, and if not there, then in the vast majority of cases to which the rule you are arguing will apply. You need to give the court a reason you should win that the judge could explain in a sentence or two to a non-lawyer friend. Rely fully on the procedural and technical points that support your case. If, for example, a particular constitutional objection was not raised below and was not addressed by the lower court, say no. Whenever possible, however, accompany the procedural or technical objection with an explanation of why the permitted point in any event wrong or the merits. Judges will indeed dispose of cases on procedural or technical ground, but they will do so much more reluctantly if it appears that the claim thereby excluded is a winner. If you cannot make a plausible case on the merits, then point out how the procedural or technical bar is necessary to ensure the correct result in the long term. A real life example: in a recent arbitration in Arkansas, the discovery cutoff came and went on February 15, by which time the parties had taken lengthy dispositions and made voluminous production of documents. Counsel had 1 month left to appear for March 15 arbitration, which was slated to last 2 weeks. On March 8, the defendants issued subpoenas to 4 witnesses employed by the plaintiffs, requiring them to produce within 5 days all sorts of documents that the defendant had never before requested. The plaintiffs objected on the ground that the discovery cutoff had passed, but the arbitrators ordered the plaintiff to produce the documents. The result: during the week before trial, while the defendant's lawyers were ready themselves preparing the witnesses and assembling the documentary evidence, the plaintiff's lawyer was scrambling to gather the documents required by the 11th hour subpoenas. The argumentative mistake: in objecting to the subpoenas, the plaintiff's lawyer argued merely the obvious. The discovery deadline had passed, and the defendant could have requested these documents much earlier. The objection seemed hardly to register in three arbitrators' mind. That's what the plaintiff could have and should have argued. Plaintiff's counsel should not be forced to stop preparing for trial 1 week away and travel to 4 cities on both coasts to find documents that the defendant never asked for before the expired discovery deadline. There is a reason for discovery deadlines. They level the playing field. If the defendants succeed in this last minute stratagem, the plaintiff's team will be severely prejudiced. 1 week from the trial date, we should not be forced to conduct a frenetic scramble for newly subpoenaed documents, nor should we be forced, in order to avoid that consequence, to request a deferral of the agreed upon trial date, further delaying the justice our client is seeking. Although we are sure the defense lawyer means well, the effective of what they have done is major league sandbagging. We urge the panel to quash the subpoenas. That might have worked. Certainly, it stood a better chance than merely harping on the deadline. If there is a prejudice, never fail to identify and arguing it. So students, this was the end of our lecture 2C. I hope that I will be catching you soon again with our next lecture, that is lecture 2D, and that will be the last lecture of the second series of the lecture. From there onwards, we will continue with lecture 3 and its subportions. Thank you students. Stay home, stay safe.